Hello and a very warm welcome to Bharata First. You're watching Big Picture with Frank Rausen Pereira. Since you're here, I would like to thank you for your continued support. For those of you who haven't already subscribed, please like the video, subscribe, hit the bell icon and then all notifications. Do follow our social media handles for all the latest updates, and you can also subscribe to our newsletter to get some incisive content. Here are the UPI IDs for those of you who would like to come forward and contribute. A small contribution you make will be a giant leap for us to keep bringing you this content. So do continue to show your love and support. All this information is in the description of the video, so please go through it. And now on to the discussion. A constitution bench of the Supreme Court has struck down the Maratha quota in excess of 50% ceiling limit as unconstitutional. The court unanimously held that there were no exceptional circumstances justifying the grant of reservation to Marathas in excess of 50% ceiling limit as a socially and economically backward class. The bench struck down the Maharashtra SEBC Act of 2018 to the extent it held Marathas as a socially and economically backward class as violating the principles of equality. The bench struck down the reservation given to Marathas in job and education. However, the bench clarified the judgment will not affect the PG medical admissions under Maratha quota made till September 2020. In this edition of Big Picture, we will analyze the Supreme Court verdict on Maratha reservation. Joining me on the program today are Lakshmi Narayanan Subramanian, former Home Secretary, Government of India, P.K. Malhotra, former Law Secretary, Government of India, and Kapil Sankla, Advocate of the Supreme Court. Thank you to all my guests for joining me on this edition of Big Picture. Mr. Malhotra, I'd like to start the program with you first. Let's first understand the key takeaways and the key points of the judgment of the Supreme Court as far as Maratha reservation is concerned.
You see, this petition before the Supreme Court, rather an appeal before the Supreme Court, was against the High Court judgment of the Bombay High Court, where the Bombay High Court has upheld the validity of the SEBC, Socially and Economically Backward Classes Reservation Act of 2018, passed by the Maharashtra legislature. However, while upholding the law passed by the Maharashtra state, the High Court reduced the quota from 16% to 13% in the services and 12% in the educational institution. Of course, we are not going into that. But what they did, the reservations of the 16% was over and above the ceiling of 50% laid down by the Supreme Court by a constitutional bench in the Indira Sahni case in the year 1992. The challenge was that no state government is competent to make a reservation in respect of SC, ST, and OBC in excess of 50%, although the Indira Sahni case permitted that it can be in exceptional circumstances go beyond 15%, but those exceptional circumstances must be brought on record. And in this case, the Supreme Court came to the conclusion that while making this reservation for Maratha up to the extent of 16%, neither the Gaikwad Commission, which made this recommendation for making recommendation, nor the High Court or not the state government has told the court what are those exceptional circumstances for which the limit of 50% laid down by the Supreme Court Indira Sahni case has been breached. The Supreme Court also said in this case that this particular, the Indira Sahni judgment has been discussed by various constitutional bench after the Indira Sahni case, and I more particularly refer to the Nagraj case, where they have upheld this 50% reservation and explained the genesis of this 50% reservation. Now, if this quota is to be breached, this can be breached only in exceptional circumstances. Those exceptional circumstances given by the state government was that the Marathas are socially and educationally backward, and they are inadequately represented in the state services, and there is deprivation of benefit of reservation to them. Now, the Supreme Court has said all these grounds are valid for the purpose of the 50% quota. If you want to give them reservation, give them within 15%. This doesn't fall within the category of exceptional circumstances. Therefore, the Supreme Court has, a constitutional bench of the Supreme Court has upheld the validity of the Indira Sahni case, and the argument made at the bar that even Indira Sahni case also needs to be reviewed by a larger bench was also not accepted by the court. And the court said that the principle laid down by in the Indira Sahni case for 50% reservation is upheld. There is no need to refer the matter to a larger bench, and the quota to the Marathas given under the State Act is also not valid. One more reason why the matter was referred to the Constitution bench was the 102nd Amendment Act, Constitution Amendment Act of 2018, under which Article 338 and 342A were added. By Article 338B, the Supreme Court gave the Constitution gave the constitutional status to the commission constituted for the OBC, and under 342A, it was laid down that for 50% for this quota also, what all caste will cover, this will be covered by a presidential order. So probably the argument was that destroy the basic structure of the Constitution, but the Supreme Court by unanimous view has upheld the validity, constitutional validity of the 102nd Constitution Amendment made in 2016.
All right, points taken. Let me take the discussion forward now with you, Mr. Subramanian. Let's also talk about this other aspect now, about how this is likely to lead to a political slugfest. And already it has started. There are several political leaders who have come out and made statements as well. Some of them have asked the center to intervene in this particular matter. Now, what do you see happening? Can the center intervene? What's the way forward for this particular issue?
Sir, the distinguished law secretary has very eloquently elaborated all the legal aspects. Now, this slugfest and all that will keep continuing to happen. I think the Supreme Court, in their best of wisdom, has done something which is for the good of the country. We are now completing more than 70 years of our independence, and it is now 75 years of our independence, and then to have these kind of again and again increasing the quota is actually compromising with merit. Yes, we should have an inclusive growth. This country has been ensuring an inclusive growth. Whichever party has been in power has been insisting on this. Yes, I am very much in favor of giving them the best of support in education, give them financial support, give them the best of support so that they are able to achieve whatever academic achievements they can achieve. But after that, while I am not the final decision maker, as an intellectual who is retired and who is still in the corporate sector as chairman of several companies, I can tell you that compromising with this merit indefinitely is not a correct step at all in the interest of the country. On one hand, we keep talking of, and we are also naturally very proud that Mr. Sundar Pichai is heading Google and Mr. Nadella is heading Microsoft and 20 other distinguished Indians are heading the various companies. Why are we not thinking why they are not in India? They are in, if we, I repeat, sir, I am not against any reservation. The country should grow by giving inclusive growth to everybody. Yes, there were deprived sections of society and we need to take care of them. We have been taking care of them for 75 years. We need to take care of them if necessary for another 75 years by giving them all backing, but not on simply increasing the quota of reservation. This is my feeling, because I have been an administrator also for 37, 38 years. One of the best run organizations today is where merit is not compromised is our armed forces and also the judiciary. I don't think there is any quota here. Yes, we should encourage more and more people who are from the deprived classes to become Supreme Court judges. We should encourage them to get the best of legal degrees. We should give them all support. Similarly, we should give them all kinds of training to be the best civil servants. But then, sir, after that, it is not a very correct system by which we keep on increasing the quota. Ultimately, you will find if the Supreme Court is very welcome that they have now taken this drastic step. Otherwise, the day was not far with this kind of slugfest which you correctly pointed out is going on. Then tomorrow there will be no sort of vacancy reserved for anybody who's got merit. It will be only by quotas. I think it is a very welcome step that Supreme Court has ultimately done what is correct for this country in the developmental interest of this country. That's all I've got to say.
Absolutely. All right. So, Kapil Sankla, let me bring you in now. So Mr. Subramaniam has, widened the scope of the discussion. So let's talk from that perspective. We have a creamy layer as far as OBCs are concerned. So why not across the board is the next question that immediately comes to mind. Of course, it's a wider topic than what we are discussing right now. But since we are here, might as well discuss that and put that also out of the way.
In deference to Mr. Subramaniam and with absolute respect to Mr. Malhotra, since I do a lot of matters, various castes and communities without bothering about their caste or community, I would only like to say this, that it hurts my sentiments when I listen to an argument which says that let us take care of them and let us help them rise up to the level of another caste and what all has been said and is usually said. And I'm saying this with a lot of responsibility because I'm a very proud nationalist. And it's always hurt me when people don't just talk about the division that we suffer from as far as religion is concerned, as far as the north-south divide, east-west divide, but when we actually also talk about the caste divide in Hinduism per se. So it kind of hurts my senses as a proud nationalist when anyone starts an argument saying let us take care of them, because I always wonder who's them. If they're one of us, then let us say that let us take care of our brethren, let us take care of our own kind, let us take care of our colleagues and friends and socially or economically disadvantaged people, but there is no them. The Honorable Supreme Court in its wisdom has passed a wonderful judgment, and rightly so. And the reason is this, that when I look at the caste divide, I actually look at what is called a preponderance of probability, which side requires more help, while also ensuring that the other side does not suffer. So the Indira Sahni judgment said exceptional circumstances, as Mr. Malhotra rightly said, exceptional circumstances excluded, you will not go beyond 50%. And it has nothing to do with merit. I'm sorry to say this. It has nothing to do with merit. There are in various castes, various communities, various religions, people who are equally important. There is an intelligent, there might be socio-economic compulsions, there could be lack of education, there could be a lot of other things. You see, we stay in Delhi. When you go to the interiors of Rajasthan and Haryana, from where I belong to, I do see a caste divide. I do see people sitting on the floor. I do see that there are different classes for them. I have seen all of that, and I've always wondered, because being a Delhi boy, why there is this divide, but it is there. I've seen that. When I do go for cases, I see the first thing a person would ask me, oh, where are you from, which village, and what is your caste? So it is all a fact of life. So therefore, I don't really agree with Mr. Subramaniam when he says that, but an absolute, with respect to him. The second part of it, the judgment as it is, as I said, rightly divided it into 50%, saying that unless and until there is an exceptional circumstance, don't go beyond that. And it was done for a very, very important reason, because states have their own political compulsions, as was in this case. You see, the Honorable Supreme Court rightly said it went through the IAS, IPS and the various lobbies and said that, they are a part of, so to say, the creamy layer. I'm using this word very loosely, but as far as their socio-economic education and their placement in the society is concerned, you cannot say that they're socially disadvantaged or economically disadvantaged. And therefore, the Honorable Supreme Court very rightly said that no exceptional circumstance has been shown. You see, the article, the amended 342A by 102nd Amendment, rightly stated that this power would be with the president, and therefore, when the state is doing this kind of increasing the quota, it has to only do it in terms of the Indira Sahni judgment and cannot go beyond it. The argument of this center and of the various states, because various states were also brought in on 8th of March 2021, when it was so said that this is going to affect various states. So please hear the councils of various states as well. The court actually heard some very prominent lawyers of the Honorable Supreme Court and gave an observation that unless and until you show an exceptional circumstance, do not go beyond Indira Sahni. Indira Sahni is good law. Even today, having been endorsed by 4 different constitutional benches. So, I mean, this is the sum and substance to it. As I said, just to conclude, let us have a very inclusive system. Let us be proud of the fact that we are Indians rather than, you know, a Vaishya, a Shudra, a Brahmin, whatever you may have. I mean, that's all that I have to say.
Points taken. Mr. Malhotra, let's take this particular aspect forward. Let's combine what the two guests have said before you and take the discussion forward now. You know, Mr. Subramanian was making a very valid point about how, you know, how we are going to have quotas, and if we keep increasing the quotas, then we are only going to have quota system and nothing else. So, you know, you've seen the case of Tamil Nadu, and you know, it has gone way beyond 50% as far as quotas are concerned. So what if each and every state follows this particular method? That is one. And the point that Mr. Sankla is making also is a very important one. When you talk of inclusive, let's be truly inclusive and not differentiate between me and somebody else.
Frank, I think there has to be a very long debate on this. What has happened in the past, what is the situation today, and what we want to do in future. I am reminded of observation made by Justice Chandrachud only last month about the reservation policy, where he, while hearing one of the cases, made an observation in the open court that a time has come when there is a need to review the reservation system. He made it very clear that we are not against reservation, but the way reservation has happened in the past, and whether we should continue in the same fashion, or it need to be reviewed and different color need to be given. And I think this stone was laid down for this, even in Indira Sahni case, where the question of creamy layer was also considered, and later on the government, by amending the constitution, talked about reservation for the economically backward classes also. So I think time has come to change the system as such. But so far as the principles are concerned, laid down by the Supreme Court, as well as under the Constitution and the Constitution as interpreted by the Supreme Court, they are very clear on the subject. Now, sometimes there may be some ambiguity in the provision of the law, because of which certain people want to take advantage, and taking that advantage, now because they say that there is no scientific formula on which the Supreme Court has come to this 50% thing. Therefore, some of these states, including Punjab, including Karnataka, including Tamil Nadu, they have gone far beyond 50%. And some of the matters are still pending before the Supreme Court. So I am thankful to the Supreme Court that at least in this matter, a quick decision has been given, because the law itself was passed in November 2018 by the Maharashtra government. And the High Court gave a judgment in 2019, June 2019, and July 2019 it came before the Supreme Court. And a 3-judges bench of the Supreme Court passed an interim order, which again was a very important order, and laid down the foundation for the judgment given by the Constitution bench yesterday. Now, within 2.5 years, that too during Corona period, through virtual hearing, the Supreme Court could decide such an important constitutional matter dealing with the constitutional validity of the Constitution amendment, as well as a law passed by the state government. So I think this has shown us a way that even during this pandemic situation also, the courts can decide important issues. If this can be decided, I mean, I'm taking the discussion a little further, and not related to the judgment itself, but with regard to the general proceeding, saying that courts and the professionals are competent to decide even important issues through virtual hearing also, and we should carry it forward. Coming back to the Constitution Bank judgment, it very clearly laid down, as Mr. Sankla has also said, upholding that Indira Sahni is a good law, and it has been upheld by many constitution benches. It made it very clear that the reservation made under Article 16, Clause 4 cannot breach the right of equality as given under Article 16(1), and there has to be a balance between the two. And that balance, the principle of that balance is laid down in Indira Gandhi and the later constitutional bench judgments given by the court from time to time. So keeping that in view, I think message has gone to the state governments that unless they come out with some exceptional circumstances, and what will be those exceptional circumstances may differ from state to state, may differ from case to case, and it will be for the Supreme Court to examine. And it is only when the Supreme Court is satisfied that here is the exceptional circumstance, only then beyond 50%, a state government can be allowed to go. And obviously this reservation has to be done by putting the caste in the presidential order, and for putting the caste in the presidential order, and under the 102nd Amendment to the Constitution made in 2018, this Article 342A was added, where the president was empowered to do it, that the state can only recommend it. Governor can only recommend it. After that recommendation, the order is to be passed by the president. And for this presidential order, there is a system laid down under the Constitution itself, and that procedure has to be followed.
Absolutely. Mr. Subramanian, let's talk about this other aspect that Mr. Malhotra raised about the EWS quota. You know, we brought that in 10% EWS quota, and, you know, it's good that we are helping out economically weaker sections of society. But we've also seen that certificates are now very easily produced, especially in states like Uttar Pradesh and elsewhere. So how do we, have a foolproof system so that only those who really deserve it get it? We are not against reservation. I think we have decided that very categorically on this panel over the last 20 minutes. But how do we ensure we have a foolproof system?
Sir, my submission is, as I told you, that we have done 75 years. We are no more a very, very young nation where we have neglected inclusivity. We have done our best to bring about inclusivity. And we should now be thinking forward how to reduce reservations instead of increasing reservations. I have done 38 years in the civil service. When I entered the civil service way back in 1970, as an IAS officer, when I was 21 years old, I was told that the other person is being given reservation, even though he has scored not even half the marks which he has scored, because we have to bring them up, and so that the poorer classes and the neglected classes are also brought at par with the so-called elite. Fine, sir. It was very, very good and a very, very holy motive which any country should have and must have, and we should continue to have. But then do you know what happened? All the persons, not even with one exception, they were third generation in the IAS. Their father was an IAS, their grandfather was also an IAS. Now I know, because I am now retired, they have also retired, the fifth generation is also in the IAS and IPS. Now my question is, has any government, has any bench or any code gone into, has it really benefited the persons whom we are targeting that we should bring them up, or it is only being pocketed by the same elite group which is now elite within those so-called neglected classes? And that is why the government said economically weaker. Now that is not being enforced at all. If economically weaker is being really enforced, then fifth generation people won't be coming into the quota of the from the quota into the IAS. They should be coming on their own steam. As I told you, time has come. We are in a very competitive world. We are having China breathing down our neck in everything, in every field, right from defense to trade to manufacturing and production and everything. We are now going through the worst of COVID. We are going to, I don't know how many more pandemics are going to come in this country. Time has come, sir, where while we should do everything possible to see that all people are brought on par in terms of education, in terms of economic development, time has come to rethink all this. I am a very firm believer in this. Well, I would like to humbly submit to my friend from the bar that I don't have a feeling that they are me. I am of the feeling, I've been as an administrator, that the poorest class has to be brought up. But what I'm trying to tell is, or what I'm trying to submit is, the best way to do it is not the way we are doing. And secondly, let us realize in this competitive global world, what is the reservation going to affect, sir? some 3% of the jobs in the sector, the governmental jobs, which are not the best now being thought of by anybody. A brilliant man would like to go to a national law school and be a Supreme Court advocate, making 50 times the practice of a secretary for every hearing. 50 times the salary which a secretary makes in every hearing. Because he is respected for his legal knowledge, or he would like to be. I am also, after retirement, the administrator of Leelavati Hospital. The doctors, for every surgery, they take 20 lakh of rupees. This is not my total saving after 38 years in the IAS. So what are we talking about? Are we really bringing about any great change in the economic stratum by reserving where only not necessarily the best are coming into the services, and even if they come, even through all this, what is it, 3% of the number of jobs available? I would prefer that you give him the best support to go to the National Law School, coach him up, see that he becomes a distinguished lawyer of the Supreme Court, and he gets justice for the people, for his own people, for the people who are poor, for the people who are deprived. I would prefer that give him the best of education. Yes, give him some reservation in the seats, but let him pass on merit. You can't say that you should get a postgraduate degree even though you are just barely passed in your MBBS degree. Please, so that we get the best surgeons. Give him 5 more opportunities. Give him 10 more opportunities to become that. Give him financial support. Give him a job immediately so that he can study more. Send him abroad. I have no issue. But then let us have the best. Because we have to survive in a world where people are breathing down our neck economically, in the manufacturing sector, militarily, everywhere. We can't afford anymore to have a country where people are still believing in all this, that I am from the inclusive class, I am from the included class, I am from the superior class. Sir, we should have only one class of people. People who are meritorious, people who are able, and people who are distinguished. They can save the country. Not these kind of policies and this slugfesting between politicians. It is high time they also realize this.
Points taken, Mr. Subramanian, spoken from the heart and spoken with experience. Thank you for giving us that special anecdote, and thank you for taking us through that particular issue as well so eloquently. So Kapil Sankla, let me come back to you now. Let's talk about this issue, and very, very valid points have been raised. There are people who slip through the system. There are loopholes that are exploited, and even in this Maratha reservation now, the talk is basically they have suggested that we use 10% economically weaker section quota and kind of get some kind of temporary relief as far as the Marathas are concerned. How do we deal with this?
See, one, I am very happy that Mr. Subramaniam agrees with me that let's have a more inclusive system where we do not have any class, caste, but we are all together. It is us and never a them. I am very happy. And this is exactly what I was saying. Frank, you see, the problem is when the Prime Minister of India is asked about his caste and he has to come and say that I am a chai wala. This is what I was saying hurts. I mean, it could be for political compulsions, it could be for vote bank politics, but whatever. But the truth is that your caste matters. And we have digressed from the topic. The topic here is whether the 50% should be diluted or not. I am a firm believer that no, it should not be divided because there has to be an equality. You cannot take away, a percentile or job opportunities from the general category. It is equally important. And yes, eventually, I do believe that this caste politics should go. But the only people who actually benefit from this are not the people from socio-economic weaker section, and definitely not from the ones who are socially exclusive or inclusive, a higher caste. It only helps politicians, and it could be state level or it could be center level. Now the question, as you said, what can be done about it is one, the amendment to the constitution saying that the power will vest with the president and not with the state is a very, very important development that took place in 2018, because it took petty politics away from state level and brought that to a higher level of the center, where the center would decide whether such and such percentage is required or not, or such and such reservation is required or not. And I am sure with this, and eventually, and let me tell you something else. Actually, I did a matter sometime, quite a few number of years back, where there was a person from Ahir community, and I think the whole case was that she forgot to mention her caste while taking some medical from some government hospital, and she had to mention her caste, and there were some government funds that had to come, etc., etc. I don't really remember, but it kind of shocked my senses that even at that time, that even today, in this era, when a person has to go to a government hospital, she also has to mention a caste if she's a Hindu. In my understanding, the fact that she mentions she's Hindu is enough, and she shouldn't even have to say that, but I don't know, probably it is for whatever reason. So, one, I am glad that Mr. Subramaniam agrees with me, and I'm in complete agreement with him that merit should come up. But till the time the government or the people or us keep on asking and keep on enjoying the fact that we want to know what somebody else's caste is, what somebody else's great grandfather did, or if our prime minister's father actually made chai or not, I think this divide is here to stay. So we need to introspect. It is not just a legal question. It is more of a societal question of how the society reacts to such things. And the day we get beyond it, when caste truly would not matter, then reservation truly would not matter. This is what my understanding as a lawyer is. And more importantly, as an Indian is.
Absolutely. All right, time to get quick closing comments now from all my panelists with the best way forward, starting first with you, Mr. Malhotra.
Yes, all I would say is many state governments have been going and passing laws and passing order giving reservation beyond 50% as laid down by Indra Sani case. With this judgment, whereby the Maharashtra law has been struck down by the Supreme Court, message will go to all the state government that the law already laid down by the Supreme Court in the 9 judges bench should be strictly followed, because that is the law of the land as on today. It is only when there are certain exceptional circumstances which will again be subject to judicial review that the court will allow to go beyond 50%. So far as the reservation policy is concerned, I think, as Mr. Sankla also said, it is going to stay here for some time more. But in what format? I think that is more important. Format need to be changed. And as Mr. Subramaniam was saying, merit should be the first consideration. All other things should be secondary.
Mr. Subramanian.
So I totally agreed with what Mr. Sankla said. Yes, this country has to get itself out of this caste system business because it has gone on for too far. Yes, to get over this only we brought about all these reservations and all that. But what I am saying is, while everybody should have an equal opportunity, in the name of giving equal opportunity, we should not give one merit to go by. 2, keep on increasing the quotas so that the day reaches when there will be nothing left for a meritorious chapter. Already many people, because of this reservation and other systems, would prefer to be a distinguished lawyer, to be a doctor and not join government service. I don't think the best of people still want to come into the civil services. Those days are gone. The opportunities which are available is more as a data scientist, more as an atomic scientist, more as a space scientist, more as a distinguished lawyer. There are so many mergers and acquisitions. I know young children of my IAS colleagues who, after passing a national law school in Bangalore, have joined the biggest companies, law firms in London and Singapore, and then they are just shuttling between all these countries. And you know, making something which an IAS officer retiring as maybe the cabinet secretary or home secretary will not make in 38 years of his service in 1 year's time. There is no exaggeration. If that is the case, we should try to encourage people to study hard, maybe give them all free education at the higher level for the people who have been deprived of this in the past, support them with the best of education, coach them up so that they come up to all these competitive exams, coach them up so that they are able to get admission in law school. It is not very easy to get an admission in national law school. You have to pass an exam. It is not very easy to. But my humble submission, sir, is after 75 years, if we keep on with all these increasing competition all over the world, when we have to compete globally and make India an Atmanirbhar Bharat, which is the vision of our Prime Minister, as my friend from the bar said, there is no question of our feeling chai wala or any wala. It should be only merit wala and somebody who is really deserves the job, whatever job he is in. That is what we should strive for. Thank you, sir.
Absolutely. And Kapil Sankla, close the show for us with your concluding remarks.
Frank, there is a saying in Hindi, "Hathi nikal gaya, poonch atak gayi." This is what my worry is with this judgment, with all due respect to the Honorable Supreme Court. You see, the concept of exceptional circumstance has yet and still not been explained by the Honorable Supreme Court. So I see no end of this litigation and disputed dates and coming. I do see that they have seen what exceptional circumstances. It has been left too vague and to interpretations of various state governments and also of the various high courts.
Right. All right. On that note, then we'll call it a wrap on this edition of Big Picture. Thank you to all my guests for joining me on the program and putting things into perspective for us. What's coming out of this discussion is that reservation must continue, but it should benefit those who really deserve it. It can't go on in the present form indefinitely. The Supreme Court verdict on Maratha quota is a welcome move, and we need to take a relook at our reservation policy as a whole. For now, though, reservation seems like it's here to stay, at least for a while. Once again, thank you for your continued support. For those of you who haven't already subscribed, please like the video, subscribe, hit the bell icon, and then all notifications. Do follow our social media handles for all the latest updates, and you can also subscribe to our newsletter to get some incisive content. Here are the UPI IDs for those who would like to come forward and contribute. A small contribution you make will go a long way in keeping this content alive. So do continue to show your love and support. All this information is in the description of this video along with other information as well. So please go through it. That's it from me. See you again next time.